It's an interesting moment in Brazil.
We're trying to emphasize that process of the lawmaking rather than a mere prescription of what should be in the law. Obviously, there are important content issues about what should be in laws, but we think that half the key to success is the right sort of a process that brings in the right people, that raises the right issues, that generates the right debates. The first is that the existence of an urban planning law starts to define, in many cases it sharply defines, the boundary. In some cases it's a jagged boundary, in some cases a sharp boundary, between the formal and the informal. The formal land markets, the informal land markets, the formal land management systems and the informal. In some cases, as I said, those boundaries are clearly defined. In most cases, those are very jagged boundaries. There are intrusions of the one into the other, but the existence of a law that determines whose buildings are legitimate and whose buildings are precarious in the eyes of the state is a very important line that gets drawn legally and which can be ignored for a long time, but when moments of crisis emerge, that the importance of that boundary, of that legal line, suddenly comes up to the surface. So we think that as we look at a continent that's becoming increasingly, in many cases, rapidly more urban than it has been until now, the role of urban planning law is a centrally important instrument in looking at the sustainability of the cities, equality within the cities, and the economic performance of those cities. The objectives which the new laws are meant to achieve are often quite common. They're generally agreed. You could crudely reduce them maybe to three things. At the outset, everybody agrees they're about recognizing and securing rights, identifying rights, including the poor, creating a framework of land and land development rights, promoting participation in urban development decision-making, and invariably these days it's also about devolution of decision-making to local government. To me, right at the outset is a failure to appreciate the political dimension of urban planning law reform. In African countries, nobody fails to acknowledge the political dimension in a developed country, but somehow there's a sense that in a developing country, in an African country, you can take a law, if it works moderately well in Sweden or Canada or Australia, you can sort of borrow it and then apply it in an African country without any appreciation of the underlying complexity and the political dimension. In countries where there's very little urban economic activity, real estate is a huge source of revenue. Controlling the supply of real estate is politically and economically an incredibly valuable tool in the hands of an elite or a grouping within an elite. The real weakness in many countries of the civil society organizations that in another context might be able to articulate more clearly and more cogently the needs and the interests of the very poor, who are, in these countries, the majority of citizens.
There are too little powers given to municipalities. The powers are centralized in central government, and the municipalities are not given sufficient powers. Where they are given powers, I think they have to try and assert themselves to exercise those powers, and they can do that by involving the citizens in participation. So we need to form an alliance with the citizenry of the cities in order to try and push the central government to listen to them much more readily.
Between local government and national government, within municipalities there's often conflict as well, and it's often generational conflict. My sense is that the young innovators seldom win. So they either become like the senior colleagues or they leave.
The informal sector occupies between 75 and 90% of the city, and it's unplanned. And the property rights which are developed there are property rights which are developed by the people there.
Informal, yeah.
So if you go in there and if you do the research, you talk to them, they recognise where the property rights are. But there's no formal legal framework for that. And there's no formal planning framework for that. What has to be developed, and this is a real problem, is how can you begin to apply the formal planning system to these areas of informal property rights. It's wrong to say there are no property rights. There are informal property rights which exist. But the property rights are there, and the planners have to recognise that they are there and to work with the people in those areas. In future, wars will not be like wars in Afghanistan. Wars will be urban wars. Wars will be wars between formal governments and non-state armed groups. Maybe opposition parties, maybe criminal gangs, whatever it happens to be. And unless one is prepared to go into these urban areas and work with people in these urban areas, you are going to find that there is an armed conflict between the state and these informal urban armed groups. First step was the Localism Act, 439 pages. That was enough to put most citizens off. Second step was a vast reduction in the amount of money that local authorities would have in order to be able to engage in anything, let alone local planning. Third step was the introduction of something called muscular localism, which was basically the minister for local government telling local authorities to do as they were told. And fourth step is the Growth and Infrastructure Act passed this year, which enables the central government to remove planning powers from local authorities and give planning permission if the local authorities aren't doing it quickly enough. They'll get the aid money and then they can adopt the practice, which is to more centralisation.
The vested interest that might oppose property tax can actually hold up the kind of path of reform in terms of land and planning. Do you know of examples? I mean, are there some examples of countries where people have successfully managed to overcome that obstacle, where property taxation has been introduced in tandem with new planning or new land laws?
I think in the case of the Village Land Act in Tanzania, where power has been delegated to village councils, there is a reasonably effective system of property taxation there, because it's collected by the local villages and could be spent in local villages.
We need to reflect more about the nature of the state. It could be the local state, it could be the central state, and how they, I mean, how benign they are. Basically, are they actually interested in these planning laws, and planning laws perhaps to sort out problems or to alleviate the problems for poorer people? They can pass laws, but as Patrick said, they may not get implemented. And I think that's the big problem, I think we sometimes put too much faith in planning and in laws. And you often see that that's not really what the issue is, because, you know, in Zimbabwe, they had most of those houses that were knocked down, all those evictions, they were perfectly legal under the planning laws because all those places were illegal. Up until that point, for a few years before that, in fact, the Zimbabwean state had been tolerating these things more and more for its own political reasons, and then it changed its mind. You know? And so that's really, it's I suppose, as I say, it's a reflection more than a question, but I am just sort of saying I'm a bit concerned sometimes about this idea that planning will sort it out if the state is not benign.
Reflecting on the position of being an international consultant and the power and politics that you possess, and thinking about that for a moment, about who checks the power of international planning consultants.
Really what led me to trying to build this platform for urban planning law reform at the African Centre for Cities was the feeling of severe disquiet, that because there is nobody who holds you to account. You know, from my point of view, there were moments I felt I was complicit. Rather, I thought I was doing something that was developmental. I thought it was quite a noble pursuit, and then I realised that it was. And you don't, in the course of your work, you don't have opportunity. You can't stand up to your client in sort of great defiance. the nature of the consulting relationship is you're often through, especially if you're from a developing country, you're generally subcontracted by a northern firm that has its relationship with the northern donor who's, so you sort of scuttle off feeling guilty. And so that's why I've been wanting to build this platform, pull together people doing similar work,